Well, it appears that Christmas came early for the defendants in the Fani Willis 19 case, including President Donald J. Trump. Now, you may recall that Fani Willis accused these 19 defendants of attempting to steal the 2020 election, which in and of itself is laughable. We've seen evidence of what happened in Georgia. We've seen 3,300 duplicate ballots on the Secretary of State's own website. We've seen people in the State Farm Arena taking the same stack of 100 ballots and feeding them through the tabulator multiple times. We've seen people registered at UPS stores, homeless shelters, and abandoned apartment buildings voting. The amount of election fraud is simply insurmountable and overwhelming. Yet Ms. Willis maintains that it was the 19 defendants that were engaging in election interference, which is, in my view, and most of the people in America, a flagrantly wrong conclusion. So Ms. Willis, in her capacity as district attorney of Fulton County, went to the grand jury and obtained indictments against 19 people. They were David Schaefer, who was the chairman of the Georgia Republican Party, Bob Shealy, who was a lawyer with whom I actually worked on this case against the Fulton Board of Elections. I was not paid. I worked as a volunteer. Mark Meadows, who was the president's former chief of staff. Donald J. Trump, the 45th president of the United States. Kathy Latham, Rudy Giuliani, Jeffrey Clark, and others. And so she brought the indictment and then proceeded to try them under a RICO statute. She employed a special prosecutor named Nathan Wade. Now, there was significant disagreement in terms of when, but it is uncontroverted that Ms. Willis and Mr. Wade proceeded to have a extramarital affair in his case, a office affair in her case, which while she was running for district attorney said that would never happen on her watch. But nevertheless, Willis and Wade engaged in this affair, and it lasted some period of time. And the date that it started is in question. One witness who worked for Fani Willis said that it happened in 2019. And then that was Robin Yearty. But then the two, Willis and Wade, embarked on elaborate travel, spanning from Napa Valley to Miami to Belize, other luxurious locations. And Ms. Willis said, she paid her share of those trips, but she has no documentation to prove it, and neither does Nathan Wade, but he's got a lot of expenses for hotels, cruises, and meals, and so forth. So you may remember that all this came to the trial court, Judge McAfee's court, and it got pretty interesting. Just to help you jog your memory, here are some clips from that famous day in Judge McAfee's Fulton County Superior Court.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
No, look. I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial. So wine, I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do.
How often did Mr. Wade visit you at a place where you were living between 2019 and 2021?
So you want to start with the lie that he lived with me in South Fulton in 2019, a home he's never been to? That's one lie you told in your document.
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller parts?
And I didn't ask about living.
But you put in your, while we're talking about professionalism, she put in 3 different documents he lived with me.
Full opportunity to respond.
And filed that with the court.
Oh, dear. Fani Willis was disqualified from one case earlier. She went after Burt Jones, the lieutenant governor of Georgia, while he was running for lieutenant governor, while she was prosecuting him in this very same case. And while she was doing that, she conducted a fundraiser for his opponent. Well, she was disqualified from continuing to serve as a prosecutor in that case. And then we saw that the conflicts of interest really only intensified as she and Wade had this tryst that lasted 1, 2, or 3 years, depending on who you believe. So the defendants in the case went to Judge McAfee and said, "Time out, Judge. This is wrong. She has got a financial stake in this case because she has paid Nathan Wade, her boyfriend, somewhere in the neighborhood of $700,000. Now, there were 2 other special prosecutors who received, as I recall, somewhere around 125, maybe 175 at most for the other 2 prosecutors individually on the case. But Nathan Wade, her boyfriend, got $700,000. Well, the court said that they could not find that created a conflict of interest, that there was nothing, no evidence presented that showed that just by virtue of her paying Nathan Wade and them being in a lover's relationship, that was inherently a conflict of interest. But Judge McAfee did say that there was an appearance of impropriety. You think? Well, so he said, and I've not been a fan of Judge McAfee's, I felt that he was extremely deferential to Ms. Willis in his courtroom. I felt that Ms. Willis took control of the courtroom. It looked like Judge Willis was presiding in the court rather than Judge McAfee at times. But that, nevertheless, Judge McAfee, to me, appeared to be very weak on the bench. He allowed Ms. Willis to filibuster in the way that you saw in that clip. And I've been a member of the Georgia Bar since 1979. I was watching it. I cringed as I was watching it. I've never seen a display like that in court, and I felt that it was extremely inappropriate and unprofessional. Nevertheless, the trial court said, here's the deal. One of the 2 of you have to get off the case. You've got to resolve the appearance of a conflict of interest by one of you getting off the case. Well, surprise, surprise. Ms. Willis stayed on the case and Nathan Wade continued. That caused the defendants to then go to the Georgia Court of Appeals. You may recall, if you are a listener of The Truth with John Gordon on Saturdays on the John Fredericks Radio Network, you have heard that I felt the judge did not do his job. Instead, he said, one of the 2 of you have to get off. Whoever you choose can remain and we'll move forward. But there is an odor of mendacity still present in the case. And I'm going to allow the defendants to file for an interlocutory order from the Georgia Court of Appeals. And all that means, folks, is Judge McAfee said, I don't want the ball. Here, you take it. I'm not dealing with this. Now, it's interesting that Judge McAfee worked for Fani Willis for 2 or 3 years as her subordinate in the DA's office. She was, in fact, his supervisor. Think that had anything to do with this? I don't know. But it's a fact, and one that I think bears mentioning. So the defendants ran to the Court of Appeals. They appealed Judge McAfee's decision, the decision not to disqualify Fani Willis from the case. And after some number of months, I think it's been 9 months, 8 or 9 months, 2 weeks ago, the Court of Appeals was to hold oral arguments in the case. And rather surprisingly, they announced a day or 2 before oral arguments that they would not hear oral arguments and that there was nothing that would be gained by having oral arguments and that they would issue their decision shortly. And today they did. And here it is, all 19 or 17 pages and a very lengthy dissent by one justice who made a lot of legal arguments. And I'm not going to get into all that. It was a lot of legal gobbledygook and an attempt to interpret case law different from the other two justices on the Court of Appeals in the way that they saw and ruled on the case. So here is the court's decision. I've read all 17 pages of it and skimmed through the dissent. Here's the gist of it. Page 17. All right, you ready? After carefully considering the trial court's findings in its order, we conclude that Judge McAfee erred by failing to disqualify D.A. Willis and her entire office. You are out. You are out of here. You are disqualified, and all the people in your office can go with you. The remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed at times when D.A. Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. So D.A. Willis is out of court, off the case, and I applaud the Georgia Court of Appeals for having the courage and the intellectual correctness to do what Judge McAfee, the former subordinate to D.A. Willis, failed to do, which was to disqualify her and kick her out of court. The one thing that I wish that the Court of Appeals had done would have been to have gone one step further and to have sent this to the Georgia Bar Association and to ask them, did D.A. Fani Willis violate the Georgia Bar Association canon of ethics justifying a removal of her from the bar or a removal of her from her office, which, by the way, would have to be referred to the Georgia Judicial Qualifications Committee.